Good evening. I'm Mike Gilliam.
And I'm Courtney Kane. We are about to hear the decision out of Ferguson, Missouri tonight as to whether a grand jury will indict Officer Darren Wilson on charges in connection to the shooting death of Michael Brown.
That announcement is expected at any moment now from the prosecutor at the downtown courthouse in St. Louis County. As we await the announcement, here's a look at the timeline of events that have led up to tonight's decision. This all started on August 9th when Michael Brown was shot and killed by a police officer. On August 15th, police identified that officer as Darren Wilson. 5 days later, the grand jury began hearing evidence in the case, and today they reached their decision.
We have a team of reporters gathering reaction as that decision becomes public. We will be checking in with them. But first, we're joined here in the studio by noted criminal defense attorney James Kousouros. Thank you so much for being here. First and foremost, we were chatting earlier about this case. You said at this point, again, just speculation, you do not think there will be an indictment.
Well, Courtney, Mike, good evening, and thank you for having me. You know, again, you're always reading the tea leaves when you're trying to figure out what a jury is thinking, what they've thought, what they've decided. But certainly the indications you're getting that the officer has not been called to surrender, that the DA has every intention of releasing this grand jury presentation to the public, irrespective of whether he has court approval. But I have to say, from my perspective, when you say you're going to announce a decision like this, with the expected public and perhaps violent outrage that might ensue at 9 o'clock at night, in the dark, when you have known this information since noon and you have seemingly mobilized your police presence and safety for days, indicates to me that there could be an indictment. So, you know, there are indications there might be, and there are strong indications that there won't be. The latest indications, honestly, are that there is no indictment.
We just don't know.
You're saying that because your feeling is that if you, in fact, did not have an indictment, it would just be crazy to do this so late at night and start all of this up.
Oh, my goodness, absolutely. You expect there to be, you know, what could be a violent reaction if there is no indictment. So you wait until it's dark, until the crowd is gathered with all the anticipation and the adrenaline running to make the announcement that there's no indictment. It doesn't make, it's certainly not a concern for public safety. Let's put it that way.
Let's talk a little bit about the actual charges that Officer Wilson is facing. Second-degree murder, voluntary manslaughter, involuntary manslaughter in the first degree, and involuntary manslaughter in the second degree. Let's kind of go over those, Jim, and talk just a little bit about each one of those.
Sure.
The first one would be the murder charge.
Well, the charges are, of course, the causing of death to a lesser degree and requiring a different mental state. If there is an indictment, I do not see murder in the second degree. What is pivotal here is what was in the mind of the officer when he fired the weapon in the two instances. And remember, there are two instances here. There's the event in the vehicle, which the forensic evidence and other evidence does seem to support the officer's story. Mm-hmm. And then you have what transpires after the young fellow runs away from the car, the officer gets out and chases him, and then he turns around and approaches the officer. That's where I think you may come with, that's where I've always thought there may be an involuntary manslaughter charge or criminally negligent homicide.
I just want to mention here, too, we have a live shot of Ferguson, Missouri, as they are waiting the information on this grand jury decision. Quite a crowd out there, and you know, we were talking about earlier, too, we'll get back to these charges in a moment. There's a lot of people that have been, you know, waiting, and people kind of wound up about this. Do you think that could potentially have some implications when this does come down?
Absolutely. Absolutely. For weeks and weeks and weeks, you know, we've been doing nothing but talking about the tension that has precipitated this decision. The manner of the presentation, why it was presented by the district attorney of that county instead of a special prosecutor. Claims of unfairness, you know, being lodged back and forth, and speculation running rampant on both sides. Mm-hmm. It's not healthy.
Let's get back to the charges. Voluntary manslaughter is defined as causing a death under the influence of sudden passion arising from adequate cause. That comes with a penalty of 5 to 15 years.
Right. Well, all of this is really going to be what is normally looked at as a self-defense claim. If, in fact, the officer was in fear and a justified, reasonable fear for his safety, then his actions will be deemed justified. The question becomes is what is reasonable, and I'm talking about the objective standard. He may have believed that he was in danger. But if a reasonable person would not have so believed under those circumstances, that's where a charge of voluntary manslaughter would come.
Doesn't it get really tricky when you get into the officer's mind, though, whether or not he believes he was in danger and that sort of thing?
Can you say 4 hours of grand jury testimony?
Absolutely.
There was 4
Absolutely.
hours of grand jury testimony
Wow.
where he was being asked, I assure you, questions by the grand jury, questions by the prosecutor, going to that exact thing. Doesn't take 4 hours to tell somebody what transpired in 90 seconds. But that's where the inquiry, the incisive inquiry would have been. And that's what took all of that time. What were you thinking every second of the way? Because that is the pivotal issue for all of these charges.
It's so incredibly in-depth. And what about the fact, too, that he has not, at this point, to what we know, been asked to turn himself in?
Courtney, that goes both ways. This is the way I feel. The family hasn't been told the decision, the officer hasn't been told the decision, because nobody trusts that either party won't let the cat out of the bag. So that fact, honestly, might be meaningless. If you told him to surrender, you know there's an indictment. And you know that there are reporters following everybody, so he leaves his house to go down to the precinct or down to wherever he surrenders. So I don't see the fact that the family or the officer have been given any indication as anything in terms of whether there is or isn't an indictment.
Okay. Okay.
Could it be that, in fact, he was going to be indicted, and for that reason, he doesn't know the outcome yet? Is that possible?
Well, I don't think he's a flight risk, so I don't think they're worried that if he finds out he's going to flee. I think that for whatever reason, and I have to tell you, I can't figure it out, but for whatever reason, this district attorney chose to leave an entire country on edge for 9 hours. And he is committed, apparently, to nobody knowing until he decides to say. So that's what I see happening here.
What about these grand jury notes? What, if there is not an indictment, what is the probability of them actually being released or perhaps leaked?
You know, you're actually asking me about how this district attorney has conducted himself. This is just one phase of it. First of all, it is my understanding that without judicial approval, you cannot release grand jury testimony or exhibits. That's number one. He apparently feels that he's got the authority to do so. But you've got a pending concurrent federal investigation that is not complete at this time. Clearly, the federal authorities do not want this evidence disclosed to the public while they are also using it to investigate. So in some ways, that could be obstructive to the federal investigation. But it is unheard of for a DA to say, not only am I not going to make the decision, I'm just going to throw it all in your lap, grand jury, and then after I've done so and put you on the hook, I'm then going to disclose what should be secret to the whole world. It is unheard of.
Okay, all right.
Once again, we're joined by James Kousouros. He's a noted criminal defense attorney. Jim, this has taken a long time for this grand jury to come up with this decision, let alone how long it's taken today to learn what the decision is. Why so long, do you think?
Again, back to the same issue, unheard of. It's not taken them this long to make the decision. It's taken the prosecution this long to present all of its evidence. This grand jury was sitting well before this shooting occurred. They, as all grand juries, as you know, and a lot of people don't know this, you have grand jury duty and you sit and you hear case after case after case. This grand jury, unlucky as they probably feel they are, was there when this case was presented. The district attorney in this case, instead of reviewing all of the evidence collected during the investigation and presenting an isolated amount of it, as he should, and then asking the grand jury to indict for charges that he deems appropriate, basically said, I'm just going to give you everything as I get it. And then at the end, when I'm done, you decide. So it's not the grand jury's fault. It's the way the case was presented to them.
Interesting, interesting. And is this particularly unique? Do you see many?
Unheard of.
Unheard of.
Unheard of.
Interesting.
Unheard of for a DA, in my view, to abdicate his own responsibility by saying, I don't want to do my job. You go and do it. I'll just give you everything. And unheard of to just give them everything as it comes in. You know, without reviewing it, without parsing through it, unheard of.
curious, too, that it seems though there's been so much buildup leading up to this announcement, this decision. How do you think this could potentially affect, in this outcome, with the outcome, whatever it may be, the way people react?
Well, I think it can have wide-ranging implications. We've got a grand jury presentation going on in Staten Island right now. We have this incident that occurred here in Brooklyn. The public's confidence in the way these matters are handled is suffering. And that's a really, really big problem. I've been a trial attorney for 29 years, and I truly believe in the jury system, and I truly believe that if people feel that things are being dealt with fairly and justly, they will decide things fairly and justly without resorting to any bias or prejudice or anything like that. I think that the way this matter has been handled has further eroded what was already a troubled perception by the public. So I think it's going to have a dramatic effect.
I think there's a real lack of trust in the African American community whenever you have a police officer charged with shooting a man of color. You seldom see them go to jail.
Can you blame them? Can you blame the perception?
Right.
And you know something? Law enforcement, prosecutors, all of us have an obligation to give the appearance of propriety. Be open. This DA, in this case, obviously did not want to make the requisite decisions. Well, that's fine. If you believe you cannot discharge your responsibilities properly, get a special prosecutor. Instead of going into the grand jury and doing it in a secret way, he had the option of filing a complaint and doing a preliminary hearing in front of a judge, out in the open. So the public can see what's presented. Because you want to know something? I believe if the public saw evidence that suggested no indictment was warranted, they'd understand.
Right.
It's when they don't see anything and things are handled in this manner that the suspicion arises.
All right, it looks as though we're probably going to have an announcement here.
Jim Kousouros is with us here right now. Jim, what's your reaction to what we just heard?
Well, I'm not surprised. And it very well may be that the evidence that was presented to the grand jury fully supports this conclusion. Again, what we were talking about before, though, is how much better would it have been if the public trust in that decision, because the process was a little bit more transparent, how much better would it be for the public trust to look at that decision and say, all right, we trust our fellow citizens, we trust that the process was fair. It's a horrible tragedy that this young fella was killed, but we accept it. It's never going to be accepted.
Let's get back to Jim now with a little bit more on what actually went on in the grand jury and this announcement. Now, the prosecutor went to great lengths to say that they heard every bit of information, all of the evidence, before coming up with this decision. What you saw him say there, did that cut it?
Well, I don't know if it cut it. He's going to release it, so I'm going to get to read it. But what I was happy to hear is that the grand jury took a participatory role. They were asking questions, they were asking for witnesses, they were asking for photographs, they looked at DNA evidence, they looked at the forensics. One thing that did strike me, and you knew that there was no true bill as he was speaking, because you heard him deriding the eyewitness accounts and then saying how the forensic and physical evidence is what we need to challenge the eyewitness testimony. That was a more adversarial stance. That was, in my view, a DA saying, this is the right decision, and perhaps I just didn't want to make it up front, so I let the grand jury make it. But this was not a neutral dissertation on the evidence, and I was also somewhat surprised that these eyewitness accounts went in before the physical and forensic evidence. That's what I was saying before.
That's typically the way that it works.
Collect it all, look at it, evaluate it, make a decision. And so did it cut it? It seems to have been complete. I've spoken before about the procedure and the manner in which it was done, and my not agreeing with it.
The real question, though, is do you think the public will be satisfied with the explanation that he gave in terms of why this took so long, the obstacles they encountered? He said many witness statements that were made were not consistent with those of other witnesses, just all sorts of obstacles that they ran into along the way.
Well, he's giving his opinion as to what the evidence was. Look, here's my problem. Of all of these people protesting, did anybody listen to that? No. The only thing anybody heard were the words, "no true bill," and so it's unfair. That tells you that the public doesn't trust, or at least the public involved here doesn't trust the process, because they don't want to hear about it. They just want to hear the result. And that is a very sad commentary on our system right now, or at least our system as it relates to this.
Speaking to perhaps they have no faith in our justice system.
Well, certainly, as Mike said before, when a young man of color is killed by a police officer, it seems to be a story that repeats itself. I mean, look, we had Crown Heights, we had the Avalon Louima case, where justice was clearly done in a very, very significant way. People do tend to forget that. Look, we've got a racial problem in our country that needs to be addressed, and it needs to be addressed in the criminal justice system and in many other systems. But to keep saying it doesn't exist, as so many do, you have evidence here that that's just not true.
How do you think you go about starting to repair that broken trust?
Well, you could have done it in this case. You had a mistrust for the system from the very beginning. Whether it was well-founded in this case or not, you had it. So acknowledge it's there, acknowledge it's a historical fact, and ask yourself as a DA, as a law enforcement official, how can I construct the process in this case to regain that trust? And to me, the answer is transparency. Get a special prosecutor, let's put it in neutral hands, and make the process as transparent as we can. And then look at the public and say, what else do you want from me? And at that point, the public's got to answer your question, because you have seemingly given them what they want. And I think that his conduct in this case, albeit sounding rather laudable here, I think a special prosecutor under these circumstances would have satiated the public's need for transparency, or for somebody a little bit more neutral. So that's just one answer.
Because there were a lot of questions raised about him at the very beginning of this whole process, and whether or not he could be fair.
Absolutely. And you want to know something? Put aside just for a minute whether he could or couldn't be fair. You're asking about a public official needing the public's trust. Cater to the public when it's a well-founded mistrust, and see if you can make it right. Work with people who don't trust the system for good reason, and do what you can, even if you're not required to gain that trust.
Well, it will be interesting to see how people continue to react. We're still going to be hearing at some point from the Reverend Al Sharpton, and I'm sure that reaction will continue.
Okay, once again, that grand jury in St. Louis County has decided not to indict Officer Wilson on those charges. We're going to take a short break here. We'll be right back with more, including the Reverend Al Sharpton.